Against intellectual property. The precise definition of intellectual property is perhaps the matter of controversy, because minute differences between definitions could entail great differences of referential scope. Wikipedia's entry on intellectual property, drawing from the source of the World Intellectual Property Organization, defines it as a category of property that includes intangible creations of the human intellect. This definition is not a bad place to start, but it is worth asking what is meant by the terms property, intangible, creation and human intellect. Property is a noun which has at least two basic senses in the English language, both of which attribute a kind of relation between one thing and another. In the first sense, property denotes a quality of some thing and consequently attributes the relationship of that thing's being qualitative in whatever given way. An apple has the property of redness, a woman has the property of sweetness, a man has the property of sternness, etc. In the second, property denotes a status of some things being owned by some person, thereby attributing a relation of ownership. The computer I made this presentation on is my property. My van is my property. I have the property of some amount of USD in my wallet that I use at the grocery store to trade for eggs and milk, which subsequently become properties of mine, etc. This second sense is the one that is employed in our working definition of intellectual property. Now, what it means to own something is itself in need of elaboration. Ownership is often used to denote the just possession of a thing, whereas on the contrary one can be in possession of a thing unjustly. Something that is stolen from someone else and held might be considered an example of an unjust possession. Of course, this invites two different questions, first of the justice, or due, of some given possession, and second of what sort of scope is actually entailed by such a relation of such possession. For instance, one might ask oneself, do I own my body? And if one indeed owns one's body, does this mean one can do whatever to one's body that one wishes? Can one tattoo one's body? Can one engage in whatever kinds of sexual activity one desires? Can one cause oneself harm or even terminate the bodily means of enduring life on earth by hanging oneself or slitting one's wrists, or to elect to a process of so-called voluntary euthanasia? Obviously most of us have the power to do these things, but if we are indeed owners of our bodies, do we have the right? If not, what is the scope of our ownership? Does it differ from our ownership of other things? In what way? These are all questions for later reprise. Tangibility in both common use and in the practice of law often denotes the sensibility of a thing, or the possibility of it being perceived through avenues of sense. Thus, the intangibility of a thing denotes its insensibility or the impossibility of its perception through the avenues of sense. Now, there are perhaps some confusions and controversies that could develop in the proposition that this or that thing falls within the purview of sensibility. For instance, while we might denote the sensation of a concrete and perdurant entity, such as a pencil or a car or a light bulb, we might also denote the sensation of feeling or emotional status, in the case of hunger or thirst or even the sensation of loneliness. This is perhaps a confusion of language. It would be proper, at least for our purposes, to say that these emotional states are responses to the particular array of presences and absences of objects. Hunger, thirst and loneliness are not objects of sensation, but intellectual responses to the absence of certain nourishing objects of sensation. This is an important distinction to make, because these intellectual responses, while they have a kind of correspondence in a perdurant entity, are not themselves perdurant, because they do not themselves inhere in dimensions of time and space even if the physical indication of their being does, for example when someone simply says they are hungry, thirsty, lonely, etc. Thus, when we denote tangible things here, we mean things that are concrete and have perdurance, such as trains, planes, cranes, and window panes, whereas intangibles shall denote things that are neither concrete nor perdurant, such as songs, numbers, designs, emotions, and stories. The latter group consists of formal causes of entities in the former group. Creation is a term that is notoriously difficult to define, and is made especially so without having first defined intellect. Its definition is made especially difficult when attempting to contrast terms like discovery and invention, and indeed without having already defined intellect. In one sense, creation denotes an action, and in another the effect of such action. The latter sense is the primary one employed in the above definition of intellectual property, But if this latter sense is indeed the effect of prior cause, it will be necessary to provide a provisional account of creative acts. One might say that any action which produces some different state of affairs is a kind of creation. For instance, the action of my walking into a room could be said to create a state of despair or a state of joy among the room's inhabitants. This would be a very loose sense of the term, and perhaps not befitting its use in our working definition of intellectual property, for the indication that the effect of creation is a product of the human intellect implies some form of involvement of the human will or intention. At the same time as having an involvement of will, creations of the human intellect often have a serendipitous property. For example, the alleged genesis of the commercial microwave oven occurred when Raytheon engineer Percy Spencer noticed that the microwaves from an active radar set started to melt a candy bar in his pocket. Spencer then constructed a high-density electromagnetic field by feeding microwave power from a magnetron into a metal box, and when food was placed inside the box its temperature began to increase rapidly. Raytheon subsequently filed a patent for this microwave cooking process. In this example, there is an array of actions that can be conceptually separated from one another. First, Spencer noticed the correlation of microwave propagation and the phase change of the local candy bar. This noticing is a conformity of the intellect to a pattern, which is either itself a law which orders things in general, or a derivative of some law, which provides a kind of subsidiary order to particular things. In either case, it is proper to call this conformity of the intellect an act of discovery. The noun discovery, if taken in a literal sense and drawing from its derivation from the Latin disco aperio, denotes the uncovering, the removing of cover, the removing of that which obscures the object from our cognizance of it. That the object of law would require the removal of obscurity and the conformity of the intellect evinces that laws are not authorized by human will, they are only expressed in human nomenclature, or reason. In mere discovery of the object of law and in the conformity of the intellect to the object, one has not yet created anything. Spencer's creative activity began when, having already conformed his intellect to the law, and of course in combination with other laws he had already conformed to, his will propagated a particular notion, that of the arrangement of an electromagnetic field contained within a metal box. This willing of the notion of the microwave oven would be the actual beginning of Spencer's creative activity. After his intellect had conformed to the law implicit in the notion, his will was then able to propagate the prototypical arrangement of the microwave. Thus, we witness an array of distinct actions in this emblematic example of creativity. 1. Conformity of the intellect to a law or laws, or discovery. 2. Propagation of a notion dependent on the discovered laws. 3. Conformity of the intellect to the law implicit in the notion, or recognition. And 4. The assembly of a prototype, or the production of a proof of concept. It is the second and third of these actions that are of most importance to our definition of intellectual property, as the property claims are not made about the object of law which is prerequisitively discovered for the notion's propagation, nor are claims made about the prototypical arrangement or any subsequent arrangement embodying the notion, but the notion itself. We have already made reference to the intellect in giving definition to creation, but our definition of creation is somewhat incomplete without elaborating the meaning of intellect. Intellect is sometimes used in a way synonymous with mind, but this is a somewhat misleading use. The former term is derived from the Latin verb intelligo, which concatenates the adjectival suffix inter, or between, and the verb lego, or to select. Placed within the noun form, intellect then best denotes an apparatus of discernment. This same apparatus is also referenced with the Germanic-derived term understanding, which itself is metaphyd from a notion of standing beneath. Mind and several cognates of the term, by contrast, are derived from the Proto-Indo-European men, and all indicate the act of thinking and thereby the thing which thinks or in which thinking occurs. Creating a visual model which illustrates the relationship between the apparatus of thought and the apparatus of discernment is not a simple task. The aim of this task is perhaps rendered even less palpable if we throw the will or intention or volition into this mix. We will not attempt here to reify the complex relation between these various apparati witnessed in the human being in a satisfactory way, but we will attempt to elaborate the distinction between the intellect and the will, since they are the active apparati and the second and third actions from the above example of Percy Spencer's creativity. The second action of the will's propagation of the notion of the microwave should not be thought of as itself chronically prior to the third action of the intellect's conformity to the implicit law of the notion, because the intellect and will are not objects which occupy the dimension of time. The behavior we witness in a person indicates the activity of intellect and will, but we do not witness this activity itself, because the objects of intellect and will are themselves insensible. The sense in which the second action is prior might be thought of as making use of the notions of before and after in an analogical way in order to form statements about a reality that is in some way beyond sensibility. Similar uses of analogy are found in theology. For instance, it is argued by St. Thomas Aquinas and others that God's goodness is not univocal with our own goodness, meaning that the term goodness means entirely the same thing when designating an attribute of ourselves and of God, but instead analogous to our goodness, such that our goodness gives us a sense of God's goodness, but not full comprehension of it. Similarly, we are here using notions of before and after extracted from their usual context of temporality in order to model the functionality of the intellect and will, and not to stipulate their sensibility. The priority given to the will in delineating the course of action is that beings which exhibit willing do not necessarily exhibit intellection. Willing without intellection is called the response of instinct. When the being has an intellect, as in the case of the human, it has the capacity to discern between the avenues of its own volition. The human intellect discerns under some auspice or aspect, rather than in the face of totality. It therefore cannot discern perfectly, but it has the capacity to discern superiorly through conformity with the order of things by apprehending the truthhood of this or that. In light of how we have elaborated on each of the terms used in Wikipedia's definition of intellectual property, we propose an enhanced definition. An intellectual property is a notional object of due possession. We use notional object in the place of intangible creation of human intellect for two reasons. 1. The notion, out of everything else which occupies the course of any array of creative activity, is what is laid claim to. 2. It is not necessary, at least as of yet, that the same person whose creativity was responsible for the genesis of a notion is indeed the rightful owner of that notion, and thus reference to its creaturehood would only be reference to its effect. Now, we have yet to determine the scope of our ownership of things, and what it is that determines ownership in general. As it happens, different arguments made for rights in general, including a right to intellectual property, operate from entirely different understandings of justice altogether. This will be made apparent, in our case, by visiting some moral arguments for the right to intellectual property. An important justification for intellectual property rights is exhibited in the U.S. Constitution's Copyright and Patent Clause, which states that the United States Congress shall have power to promote the progress of science and useful arts, by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This justification explicitly designates the end of the progress of science and useful arts, but since the security and perpetuity of any given monopoly depends on the arbitration of Congress, this end must be in some way derivative. In fact, the designation of the arts in mind as useful makes this rather obvious. Of course, American intellectual property customs did not begin with the Constitution, and they were present in colonial America before the Revolutionary War, and in all likelihood, the custom is here to stay in some form or another. Thus, it is prudent to give mention to the more commonplace justification for intellectual property rights, which follows the form, well, how will X get paid otherwise? These arguments appeal to the compensation of musicians, writers, engineers, and so on. What these two arguments have in common is that they argue from consequence. The former largely has national interests in mind, while the latter has the interests of individuals in mind. There is a tendency for people, when arguing for intellectual property rights, to vacillate between appeals toward either interest. Nevertheless, there is some kind of appeal to some interest for which the right is designed to satisfy. Thus, the limit of the right by these conceptions appears to be its utility toward the end of some interest. However, consequentialism in normative ethics is riddled with internal problems and questionable presuppositions. We will not here deal with every account and every stripe of consequentialism the agora of the Internet has to offer, but will provide a basic argument that displays one of the main continuing issues with the entire vein of moral philosophy. Consequentialism is a faith that pretends not to be, which is a clear mark of any false religion. In denying that there is such a thing as an intrinsically evil action and asserting that the good of any action lay entirely in its propagation of some consequential state, the consequentialist must believe that he or some lawmaker or group of lawmakers can reliably predict the future. Of course, we can make judgments of certainty about what the future will be like based on our observation of natural order, but we cannot produce a holistic picture of the future, especially when describing the future state of a species as complex as our own. Many of us make arguments from consequence for reasons of intellectual expedience, and this is perhaps permissible, as an argument from consequence does not necessarily entail the premise of consequences determining moral norms. For instance, a mother might tell a child not to steal a cookie out of the cookie jar and spoil their supper because it will make their father furious with them. This could very well be interpreted as a moral instruction appealing to fears of repercussion, as opposed to proposing a norm. But in attempting to construct a rational basis for ethics, we cannot use arguments that are merely defeasible in this situation or that, and when we subject consequentialism as it pertains to norms to rational scrutiny, we see very plainly that the consequentialist, regardless of what consequences he aspires toward, tacitly believes he or some bureaucrat has divine foreknowledge. Thus, we propose an alternative to any vindication of rights based on a consequentialist ethics, namely, natural law. Of course, natural law has controversies of its own. An important controversy in the history of natural law theory was outlined in a lecture given by Professor Nigel Bigger entitled What's Wrong with Natural Rights?
A seminal moment in the articulation of a concept of a natural right was the 14th century Franciscan controversy about the status of private property. In 1321, Pope John XXII launched an attack on the Franciscan doctrine of absolute apostolic poverty, which held that the renunciation of all property rights was essential to the teaching of Christ and his apostles, and so to evangelical perfection. Quite what caused the Pope to make this attack is not clear. Concern about the subversive implications for church property and authority seems likely. Whatever the cause, the effect was his development of an argument that private property is natural. Pope John argued that a right to use something does not confer the right to destroy and consume it. Only a right of ownership confers that. Therefore, insofar as the Franciscans consume food justly, they own property, and they have a right to it. As with the Franciscans, so with Adam in the state of original innocence. He had dominium or ownership over temporal things, and so he had the right to consume them. And he had this right even when there was no one else to exchange commodities with. Therefore, the right to private property is natural. And it's natural in the sense of being primordial and ideal, not merely in the sense of being a reasonable, morally justified, pacifying way of responding to the conflict engendered by sin. Whatever his motives, in asserting the natural right to property as primordial and ideal, Pope John went counter to the whole tenor of the canonistic tradition that he had inherited. Inspired by the common ownership of goods in the early church, as recorded in the Acts of the Apostles, this tradition shared with some early fathers a suspicion of and even hostility towards the very notion of private property. Thus St. Ambrose, "No one may call his own what is common, of which if a man takes more than he needs, it is obtained by violence." According to this view, private property is not natural in the sense of primordial or ideal. Rather, as the 13th century canon lawyer Higuccio put it, it is a social convention justified as a prophylactic against the sins of covetousness and avarice. This tradition of a morally conditional affirmation of private property was represented against the Pope by William of Ockham, who argued that Adam's original dominion was granted not just for himself, but for the sake of Eve and their progeny too. That's to say, it was a natural, inalienable, morally justified power of using commodities as necessary to meet common needs. It was not a natural right to own property. After the fall and in the condition of sin, however, reason dictated that it was expedient for individuals to appropriate things to themselves. Only then, therefore, did a right to private property arise through social contracts enforceable by judicial institutions. To put the matter in David Ritchie's terms, the positive, legally established right to private property is morally justified by its social convenience. It prevents anarchy. It is not natural in the sense of ideal, but is a morally reasonable institution necessary for peaceful social life.
The saying of St. Ambrose, "No one may call his own what is common, of which if a man takes more than he needs, it is obtained by violence," purportedly draws inspiration from the account of believers in Jerusalem from the Acts of the Apostles, 4:32-35, "And the multitude of them that believed were of one heart and of one soul, neither said any of them that aught of the things which he possessed was his own, but they had all things common. And with great power gave the apostles witness of the resurrection of the Lord Jesus, and great grace was upon them all. Neither was there any among them that lacked, for as many as were possessors of lands or houses sold them, and brought the prices of the things that were sold, and laid them down at the apostles' feet, and distribution was made unto every man according as he had need." Ambrose's doctrine is reminiscent of the socialist dictum most infamously used by Karl Marx in his Critique of the Gotha program, from each according to his ability, to each according to his need. However, the difference of formulation indicates perhaps a difference of principle. Ambrose's formula is a declaration of presumed fact, whereas the socialist formula is a declaration of an imperative. Where the former is merely descriptive, the latter prescribes action, and it does so precisely by way of its additional article, from each according to his ability. Ambrose, by contrast, does not submit to any particular principle of redistribution, and indeed the above passage from the Acts of the Apostles does not indicate any formal declaration of a distributionary moral imperative, but the commonly held belief that all things were held in common and a particular instance of the redistribution of wealth that was submitted voluntarily by those in possession of it. Even if this historical distributive act is deemed from ability and to need, Ambrose's dictum itself does not explicate that it ought be considered normative or that any particular principle of distribution ought be considered normative, but simply that to possess more of what is common than what is necessary is to do so at the expense of the commonwealth. This should be taken into account before retrofitting socialist ideas onto the apostolic age and patristic literature. Of course, Ambrose's doctrine does invite questions of what is indeed necessary, and how this could be determined with any regularity, especially in a world as complex as our own at present. What actually constitutes necessity, in the sense of man's needs, is certainly controversial. The very stipulation of need indicates that there is some end of which there is a moral obligation to satisfy. What are these ends? Proposed needs, such as food and water and shelter, tend to indicate that, at minimum, the general endurance of life is an end. But how much food and how much water, how much shelter, for how long is one obliged to provide this for another? It is far easier to respond to some obvious, particular need with a temporary measure of alleviation than it is to generate a principle. Indeed, the fact that in the Acts of the Apostles the recompense for earthly possessions was given to the apostles rather than directly distributed to those in need demonstrates that need is something indeterminate and ought to be attended to in ancillary or otherwise procedural sort of fashion. Pope John XXII's doctrine of dominium was intended as a solution to the dispute between different factions of mendicants over the meaning of their vow to poverty, and in particular a suppression of the more extreme and Joachimist views of the spiritual Franciscans, who generally held that Christ and his apostles possessed absolutely nothing separately or jointly. This is referred to as the doctrine of absolute apostolic poverty. John XXII's doctrine, that only a right of ownership could confer just consumption and/or destruction, entailed that notions of absolute poverty were legal fictions. While Bigger sets John XXII at odds with the tradition before him, and in particular the saying of St. Ambrose, it is not entirely evident that this is the case. It does not follow from the observation that no one may call his own what is common that all possessions are, de facto, held in common and distributed to individual use, nor is there anything in the Acts of the Apostles that explicitly promotes the imperative of commonality of all property in any absolute sense. Indeed, Pope John did not in his encyclicals propose that there is no jus utendi, or the right to use, but merely that it cannot be the right which allows ordinary human activities, such as the consumption of food, which only the jus abutendi, or the right to dispose, could possibly allow. We need not stipulate that there is some necessary conflict between the two rights that prevents their coexistence in natural law. We ought to follow this up with two more questions. 1. What does it actually mean to dispose of something? And 2. Of what things do we have this form of dominion, and of what things do we not? The common understanding of destruction in the context of jus abutendi is a disintegration of a thing such that its original substance is rendered naturally irretrievable. So, for instance, if I eat and digest an apple, presumably I would not be able to reverse the process of digestion and chewing such that the same apple could be returned to its prior status. It follows a fortiori that consumptive acts are necessarily destructive, and that the only legal basis for nutrition itself must derive from jus abutendi. Therefore, all consumable goods, that is, those goods which are goods in virtue of the particular manners in which they can be disintegrated, must at some point become the just possession of an individual, even if they are commonly held before allocation to the individual's estate, if any form of nutrition falls within the scope of need. Of course, this argument only tells us that we must have some right to jus abutendi. It doesn't tell us what is properly conceived of as common and what is properly conceived of as private. This second question is a much more daunting one, and indeed it deserves its own treatment at length. However, we have already established enough about the jus utendi and jus abutendi to argue that a natural right to intellectual property, as commonly understood, is entirely irrational. Returning to the example of Percy Spencer's notion of the microwave oven, we can pose the question: can the notion of the microwave oven be destroyed, per the understanding of destruction outlined above? The answer is, of course, no. Even if we somehow eradicated every particular microwave oven in the universe, we would not have eradicated the notion of a microwave oven, which has no local, temporal existence. We could certainly eradicate the efficient means of accessing such a notion, such as the blueprint design of a microwave oven. But we still would not have eradicated the notion itself. Similarly, we cannot disintegrate anything which is absent of intangibility. We cannot, properly speaking, disintegrate hunger, thirst, sorrow, happiness, songs, souls, and so on, because these things are intangible. Thus, to speak of a natural right to intellectual property is to speak of a right to destroy something that logically cannot be destroyed. It is therefore no mystery why, in arguing for the right to some intellectual property, consistent appeal is made to some consequence or another. Intellectual property can only be seen as a right conferred as a political prophylactic of some kind. The moral question is then, is the means of a state-sanctioned temporary monopoly justified by the proposed end of the individual or the health of the state? Because the means entails a rather arbitrary pattern of coercion, and the end of individual or collective prosperity is certainly one that can be arrived at through a variety of means that are not morally dubious, we maintain that the custom of intellectual property requires acts that are intrinsically evil. Not only this, but like other presumed value production schemes that require evil activities, such as usury, the industrial norm of intellectual property, on the whole, produces a loss of value. Business models which utilize this legal custom are often engaged in a kind of rent-seeking activity in the form of charging others for the license to utilize some notion or another. This is at best non-productive, and at worst counterproductive. Things which displease God are often worth pursuing only at our own peril. Therefore, we would be well advised to opt out of ecosystems which provide us with our earthly needs and wants, but within which participation in the custom of intellectual property is obligatory. Because of the principle of double effect, i.e. the principle that one is not morally accountable for unintended but expected consequences of some given action, complicity with business models that utilize intellectual property is morally permissible. But we may, and indeed we should, resort to other options if we are able. Under certain circumstances, the custom of intellectual possession, like most parasitic behaviors, can be a self-correcting problem through the mechanics of so-called selective pressures. However, we shouldn't assume that we can tolerate this problem out of existence. Other activities that are contrary to nature, such as sexual perversions, do not seem to disappear from society when given license to persist without the molestation of civil authorities. In fact, It could be argued that toleration of such perversions has provided the experimental space needed to multiply perversity. In a similar way, intellectual property is a custom that will likely continue to exist so long as economies of scale provide demand for rapid innovation. A crisis like a pandemic provides the impetus for developing incentive structures like patent protections awarded to the first developers of vaccines. Crises like these, whether or not they are truly crises or merely appear to be, are fecund with rhetorical avenues for public vindication of morality, and often go unscrutinized because of how quickly policies go into motion. We might wonder, then, what can we do in our day-to-day life to combat this parasitic tendency in culture and law?